Okay, I'm going to start with some housekeeping. I'm aware there's some of you still joining us, but the first couple of minutes, if you're not new, you'll have heard this before, so don't worry. Welcome to today's webinar. I'm Anna from the TUC. I'm joined by John Handley, one of our really great and experienced tutors from TUC Education, and I'll be getting him to introduce himself more thoroughly in a minute. But just a bit of housekeeping first of all. I can see lots of you already introducing yourself in the chat panel. That's great to see. Please do tell us where you're from, your workplace, your union, and we will, of course, be discussing facility time and time off for trade union duties and activities. So do talk about that as well if we mention something that's relevant. You can, of course, follow along with live captions. At the bottom of the screen, there's a show captions button. You can click that and follow along with those captions with the live video. We will try and save some time for some questions to John. So again, at the bottom of the screen, there's a Q&A button. It looks like a speech bubble with a question mark in it. Please do post your questions there and we'll try to get to some of them after we've covered our main points. And we are, of course, recording today, as we always do. We will send you a recording of this live webinar, along with any resources that we mention tomorrow morning. Along with any of you who are here live will also receive a TUC digital credential to show what you have learned today. Right, that's enough of the housekeeping. Just a little bit about today's subject. We're talking about time off or facility time for union rep and health and safety rep and union learning rep duties and activities, and what you can get and what you can use time for. I've got a series of questions that I'm going to put to John, and we're going to discuss what you're entitled to, some of the problems that there might be, and how we can overcome those. So, first of all, John, can you just introduce yourself? Tell us a bit about your background and your work in this area.
Yeah, hi everyone, good afternoon. My name's John Handley, and thanks very much, Anna, for your introduction there. I work out of Stockport College Trade Union Education Centre, and I've been a trade union educator there for a long time now. We tend to be doing a lot of, me personally, working online. Anyway, enough of me. The subject is the important thing. And as Anna said, we're going to talk about the facility time, essentially, and the paid release for you to be able to carry out your duties. So I think the first thing what I'm going to try and do is, first of all, give an overview of the legislation that supports our rights. Then we'll look at some sort of ideas of how we can make the most of our facility time. And when we have problems with employers, try and explore some ways that we can actually understand and make a better use of our time with negotiations with the employer. Anyway, that's the plan. The background, really, when we look at the our facility time, our time off for our duties, it goes right back to the Employment Protection Act of 1975. Everything was then consolidated in terms of facility time, time off for our duties and activities under the Trade Union and Labour Relations Consolidation Act of 1992. And the sections involved a 168. Often our duties are considered a 168 duty. So you'll often hear that phrase, and our activities are a 170 duty. As time went on, under the Employment Act of 2002, you might be interested to see the different the time scales and the years used here. But the ULRs got the same sort of rights to be able to carry out their duties in the Employment Act of 2002, which was subsumed into the Trade Union Labour Relations Consolidation Act now under Section 188. The same thing happened to the transfer of undertaking regulations. The TUPE regs gave time off for consultations over TUPE regulations. Similar things happened over redundancies. So all of these points came up to it. Now, the, under the Trade Union and Labour Relations Consolidation Act, and that's a long phrase for me to say every time, so I may say the 1992 Act, you hopefully will understand what that means. And what it says is the 168 gives an entitlement. Now, what we've got to remember is this is the law. This is an act of parliament, and it says that an employer shall permit an employee who is an official of an independent trade union recognized by the employer to take time off during their working hours for the purpose of carrying out any duties. We'll come on to the types, what are duties in a little while. The employer shall also permit such an employee to take time off during work hours for the purpose of undergoing training in aspects of industrial relations. Now, and the amount of time off which an employee is to be permitted is reasonable in all the circumstances. That's a very important phrase, but they has to take into account any relevant provisions of the ACAS Code of Practice, Code of Practice 3, on time off for trade union duties and activities. And if we don't get our rights, our entitlement under this, we may be able to present a complaint to an employment tribunal that our employer has failed to permit us our reps time off as required under the legislation. Okay, so can we have the next slide, please? Thanks. So what happens next, if you like, is that Section 199 of the 1992 Act gives ACAS a duty to provide practical guidance on that time off to be permitted by the employer. And it gives, as I mentioned, under 168, to a trade union official. Now, the trade union official means representative. In fact, ACAS clarifies that in their guide. The legislation refers to a trade union official, which is an elected representative, not for the purposes of this, not a paid official of your union. And that now includes ULRs. And also to a trade union member, any member, including reps, with Section 170, and that gives us our rights to our activities. And that, again, is ACAS has provided practical guidance of how all of that works. Okay. Quite often what I get is, well, it says in the ACAS guide that the failure to observe the code does not render a person liable to any proceedings. So this is a popular question from reps on any of the courses that we do, because how can they use this right if the employer just points back to them immediately? Failure, I don't have to take into account this ACAS code. Well, in fact, they actually do. So what we can see is that it says that, and even in the ACAS code here, it says any provisions of the code which appear to the tribunal to be relevant shall be taken into account. Okay, next slide, please. And if you can just go through these, yeah, Act of Parliament. So in terms of UK law hierarchy, we have an Act of Parliament. That is the top of the tree, if you like. Underneath that, we have regulations and statutory instruments. Underneath that, we have codes of practice, and then we have guidance. Now, all of these are really important because they're all part of the law. And the idea is, if you follow the guidance, you will comply with the Act of Parliament. If you follow the codes of practice, you will comply with the Act of Parliament, and so on, regulations. And there is that sort of hierarchy, if you like. Quite often, Acts of Parliament are umbrella acts with the regulations and codes of practice underneath them. So just go back one for me, just that important point at the end. A breach of the code of practice or guidance is not necessarily illegal, but would need to be directly linked to the primary legislation. And that goes for majority of UK legislation. So I often give the example of the Road Traffic Act, the various regulations for driving particular types of vehicles, heavy goods vehicles, passenger transport vehicles, etc., and the code of practice for that, which is the Highway Code. And if you fail and don't observe the Highway Code, you will be prosecuted not under the Highway Code, but under the Road Traffic Act. And it's the same with this Trade Union Labour Relations Consolidation Act and the ACAS Codes of Practice. Okay, let's move on. Okay, on top of that, we just mentioned the guidance. Actually, ACAS gives further guidance as well. And there are two guides, one for non-union representation. We'll consider only trade union representation because the non-representation have no rights really. So trade union reps in the workplace is the ACAS guide, and that spells out in a bit more detail some practical applications. All of them are worthwhile looking at because if you have any problems, you can show that guidance would suggest a way out of it. On top of that, we've got union health and safety reps functions, which are included as in the SRSC regs. Now, the same thing happens. The health and safety reps are given the right to time off under the Trade Union and Labour Relations Consolidation Act, but also it's spelt out more clearly in a regulation, which is probably a little bit higher in the pecking order than a code of practice. Okay, let's move on. So what the 1992 Act actually gives is examples of duties. And they talk about the terms and conditions of employment. So these are your duties that you, as a rep, are able to look at. So the terms and conditions of employment, any negotiations regarding that, the engagement or non-engagement or termination or suspension of employment, or the duties of employment, allocation of work, groups of work as matters of discipline, and so on. So a lot of the examples actually written down in law that you have the right or your duty is to negotiate on. Okay, just next slide, please. On top of that, I won't go through all of these, but the ACAS Code of Practice 3, paragraph 13 or section 13 has the following things. It spells out a bit. So where that title before from the 1992 Act said terms and conditions of employment, ACAS gives examples, practical examples: pay, hours of work, holidays, sick pay, pensions, learning and training, equality and diversity, notice, the working environment, etc. So there's an awful lot of things that you as have a duty to talk about. And you need some time to do that. You can see that the ACAS code goes into all of those titles from the Act and gives some practical examples. Okay, next, please. If and when you get the time off, the Act actually says that the employer shall pay for the time off pursuant to the permission. So if somebody gives you the permission to attend these meetings, they must pay you the time off to attend. And ACAS again goes into a little bit more detail, says an employer who permits union reps time off for trade union duties must pay them for the time off taken. The employer must pay either the amount that the union rep would have earned had they worked during the time, etc. So we can see that we've got all of these things that you can see how the law works. You know, the Act lays out a basic framework and the ACAS codes actually fill in. Okay. The other question we have quite often is, what is reasonable time? So reasonable time is under section 168 of the Act, says the amount of time which an employee is to be permitted to take under this section, the purposes for which the occasions on which and any conditions subject are reasonable in all the circumstances. It's a phrase that often gives us problems, to be honest with you, because it makes that duty a qualified duty. So what we have to show is that everything is reasonable in all the circumstances. Now, quite often you get an employer saying, well, I don't think that's reasonable. The rep would say, or the union would say, well, I think it is reasonable. So who makes the decision? And in that case, if we can't come to an agreement, then what we have to do is go to an employment tribunal. And the employment tribunal has provided much case law over the years for different types of cases. And there's two here, contrasting outcomes. Um, One, Wignall against the British Gas Corporation um, had one refusal that the tie-off was reasonable. The one, Carberry against the Bedford Fire Service, actually Mr. Carberry won that case, and the proved that the fire service didn't act reasonably in all the circumstances. And they're interesting cases, but you can see quite easily why if you have a look at both of them, exactly why one was deemed unreasonable and the other one was deemed reasonable. Okay. Okay. So, and again, if we have a problem there and we win the case, then where the tribunal finds a complaint is well founded, it shall make a declaration and actually award compensation. It can also award other things as well on that, particularly if there was a malicious intent from the employer not to provide that time off, paid time off. Okay.
Thanks, John. Should we just pause there for a quick second? Because I just
Of course.
wanted to highlight a couple of the points that have come up in the chat while you've been speaking. Yes, everyone, we will be sending you a copy of these slides resources along with the recording tomorrow. Please don't think, you're not going to be able to see them. So any links that are in the slides that John has highlighted, you'll be able to read more about those as well. I'm just thought before we move on to the next bit, there's quite a few people have posted in the chat to say that as following from local election results last week, they now work in a reform controlled or local authority, and they wonder what might happen when in discussions and negotiations around this. Perhaps, John, you can let that percolate and we'll come back to that later on. So are we ready to move on to enforcement, or was there something else you wanted to go back to first on the hierarchy of rights?
No, no. I think let's move on. Or
Yeah,
wherever you want to pick up, we can pick.
sure. So we've talked about a lot of the rights there, and this is all, we all can look up our rights, but we know that sometimes the practical application, it doesn't always work as smoothly as perhaps the code of practice or the regulations or the guidance say. So can you tell us a bit about the problems reps might have with enforcing these rights? And then maybe some of the problems they have about getting the time that they need, perhaps within a facilities agreement that already exists.
Yeah, sure. I think hopefully I'll be able to answer those questions. You may have to remind me of one or two of them. But I think the first thing is that, how do we secure our rights? Well, it's part of our recognition agreement. If you are working in an employer that recognizes the trade union, then all of these rights apply. And essentially the recognition agreement actually specifies it in more detail. So it's always worth looking at your recognition agreement. And probably what happens is that your recognition agreement is signed by somebody at the top of the organization, the top of the employer, usually a director or in smaller organizations, the chief executive. Sometimes it's delegated to a director of personnel. And also it's signed by a senior member of the trade union, potentially a general secretary deputy general secretary, or something of that ilk. So it's really high level stuff that they've agreed to have a voluntary agreement, usually between the two sides, to say we recognize the trade union, and we do that for all of the reasons spelt out in the Trade Union Labour Relations Consolidation Act and the ACAS Codes of Practice, which is all about providing good industrial relations. I mentioned about the years that these sort of things came out, and if you look at the 1975 Act and the 1992 Act, they came out during periods of what we often think of in the trade union movement as very anti-trade union legislation, and yet suddenly they gave us all of these rights. Why was that? Well, I think essentially it was because they wanted better industrial relations. They didn't want strikes every 5 minutes, and they wanted trade unionists to be trained so that they understood what the law said and that they could work in a more harmonious way. Not saying whether that happened or not at that time, but anyway, that was the idea about it, and that's the whole point of this. So, in part, answer to people who are saying they're now members of a reform-controlled local authority. That was the reason behind it. So it's always good, I think, to argue with your employer that actually this is good for business. It's good for the economy. It's good for their employment, and it saves all the angst and problems going forward. So I think so that's one thing. Um, okay, now just remind me again, Anna, exactly where I'm up to here. I tend to go off on little bits of
No worries. Just to tell you, I don't know whether you can see the chat that's going by as well. People are really loving the information. They find it really helpful. They want the detail. So it's all great. You know, don't worry about going off on little tangents.
my time.
Um, we've had a couple of questions that have sort of come up related to what you've just said. Um, but and also what I was sort of moving on to next is, what if you've got a recognition agreement that isn't perhaps divided as helpfully as it could be amongst the reps in that workplace or in that branch? Is this something you come across at all in your work?
Yeah, it is. Yeah, I mean, we often get sort of reps who have got lots of experience, and they tend to get the vast majority of the facility time if there is a divvying up of the facility time at a particular employer, and younger, newer reps tend to get less facility time. That usually changes over time with experience and so on, and their ability to take on more casework, etc. Um, so that's one thing. I think the other thing to point out is where I just about got up to with the signing of the document between, the high levels. When it filters down to the line manager, quite often, and I'm not blaming line managers get kicked from above and they get kicked from below as well. So I do have some sympathies with line managers, but they tend to get promoted into a position where they don't have the same training as we do. They don't understand what the ACAS Code of Practice says. They don't ever, and probably have never seen the Trade Union Labour Relations Consolidation Act. So they don't know that, and they presume, depending on how they've been treated by their line managers in the past, that their new role means that they have to act as the boss. And therefore, we get at the very high level an agreement. It doesn't filter down because people don't get trained, and that is a real sore point usually. So we can do some things which we'll come on to in a second. But the other thing is, in terms of your the divvying up of facility time, what the law says is the duties that you are doing, you need reasonable time, which has to be reasonable in all of the circumstances. So I remember as a rep at ITV Granada for many years, I was offered a facility time. They said, we'd like to give you some facility time. What do you want? Do you want a day a week? Well, actually, I didn't need it. and I was a news cameraman at the time, and I loved my job, and I wanted to be on the road as much as I could. So that was another point really. But at the same time, um, when we had redundancies, um, those redundancies meant that I had to negotiate. We tried to reduce them, and all the way that every other rep would do. I had to sit through one-to-one meetings, and we had 1,300 redundancies. That's a lot of redundancies. I was out of the game, not doing my work and being paid my full rate for 3 months. That was reasonable in the circumstances. Conversely, the reasonableness of just keeping in touch with people about individual problems didn't take much time at all. So both of them were examples of reasonableness as the law sees it. So I think that we all must understand what that means. And that means that if somebody is tasked with doing something, say for instance, you are a young rep in an area where the facility time is divvied up, what we find is that a rep might need training. Well, that would be over and above perhaps what their facility time says, because that would be reasonable for them to be trained. It would mean that if they were following a grievance or disciplinary procedure, and they were representing someone as their rep, then they would have to have the time that might go over and above that facility agreement. That would be reasonable as well, unless the branch decided that we're going to give this to someone else who's got more facility time. So I think that's the way it would work in my view. What the law says, it has to be reasonable.
Thanks, John. Another question that came up in the chat that I've noted down that's about time is someone has asked, what happens if your agreement with your employer doesn't specify time in like numbers? What would your advice be then?
I think that's a similar thing, isn't it, really? It's what is reasonable in all of the circumstances. So I think what we can do is sort of second guess things. Sometimes it's that problem with the line manager. And by the way, the line managers often change. So you just get one trained up to do what you think that they should be doing. And the next minute they've gone and you're faced with someone else who has a different attitude, sometimes positive, sometimes less positive. So sometimes it is a good idea for the branch to actually enter into an agreement um, and flesh out the um, the the recognition agreement. Now, I'm not suggesting for one moment that you go and say, I think we should renegotiate our recognition agreement, because quite often the employer would say, oh, yes, so would we. And then you're left in a bit of a problem. So what we're looking at is trying to provide a policy, if you like, under the recognition agreement that suggests how time off should be given. And I don't know whether we've got time to go back to the slide now, but the slide on time off agreements may be useful here.
Yeah, let's go for it.
Okay. Okay, so I've just put a few notes here. In terms of having this type of an agreement with your employer, I've put down some pros and cons, basically, mainly pros here. What it does actually is sets an agreed understanding between the employer and the union, in other words, the line manager and the rep, of what constitutes reasonable time. It can avoid misunderstanding. So if you suddenly say, I need to represent someone, your line manager says, well, I can't release you. You've got a job to do. Actually, if you preempt this with an agreement, you can point to that and say, look, this is the way we do things. And that would benefit new managers, existing managers, or whatever. So it also allows the employer to plan. If you know that you're going to be doing something that will require time, training, for instance, they can actually plan around that because they know in advance. And that is hopefully would be a positive thing. It also makes sure of a consistent approach that's fair and reasonable to all reps, so that one line manager in one department doesn't treat their rep differently to the line manager treats the rep in a different department. We have a consistent approach across the employer. So that's some of the points of having this agreement, this policy, if you like. And I'll say policy because I don't want you to go back starting talking about renegotiating the recognition agreement. Obviously, some of the points you could include would be agree the amount of time off to be permitted on a regular basis, so you can hold surgeries, so you can discuss things with people when people have a problem and want to come and make an appointment to see you. When people have been told that they're facing a disciplinary meeting or they want to raise a grievance, all of those could be reasons for which time off could be taken, when and why, and so on. How time off would be paid, so there isn't any issue. If you're working a night shift and you have to come in to see someone on a day shift, then all of this should be included. Obviously, who would be paid? The rep, and also how to make that request. The entitlement comes once we make a request for reasonable time off. Now, these agreements can preempt that again, by having it all in one document, and how you make this idea of a reasonable request. Now, I think one of the things that on top of all of this is that quite often you're in two types of workplace. You're in a workplace, and we can lose the slide for a moment. Thanks. We can if we're in a particular workplace which has had good recognition, with a well-established branch structure, with people being trained and leaving in the branch rep's role. That's one thing. That's very easy to maintain, usually. It's when people are trying to have it's a young branch, or there is somebody's trying to get the thing off the ground, or you have a particularly belligerent line manager or departmental manager or even area manager that really wants to restrict the use of this. Quite often, I think, don't suffer on your own as a single rep. Discuss it, if you can, with your branch. If you don't have the branch, talk to other reps. Perhaps there is a network in a local area, or regional committees or whatever, and discuss it there. Have no problem about talking to your paid full-time official of your union, because your role as a rep is vital to the trade union movement. Without reps, the trade union movement would collapse, because we wouldn't have the money to pay and do all of the things that reps do. So you are a really important resource, and you should be supported by your union. So if you have a problem, and I've done this myself and I've recommended it to other people, make an appointment, talk to your full-time official, ask them to make an appointment with the head of HR and any relevant line manager, and go into the discussion with them. Highlight all of the things, what the law says, the ACAS codes, the Trade Union Labour Relations Consolidation Act, etc., and have that upfront discussion and try and come up with some form of an agreement. And that will save a lot of angst and a lot of problems as you go through the first, maybe, sort of small steps of setting up your branch.
Thanks, John. That's really helpful. So I think we'll move on to the last set of questions I've got for you before we look at some that have come in, about, we've touched on this already, but overcoming some of the barriers and overcoming some of the problems that we might have with enforcement. I mean, you've already mentioned that we sometimes have difficult line managers, and some of the things we can do with them. But what are some of the other things you might add in here that would help reps negotiating or enforcing their rights?
I think it's that thing. Don't give up. I mean, your rights are enshrined in law. It is the employer who would be in breach of the law if they failed to give you reasonable time off to perform your duties. And let's not forget what we've got. We mentioned before about activities. All reps have activities. So activities usually are under the sort of things like holding meetings. Um, for a rep to report back pay discussions, and having meetings in the canteen, or things of that ilk. Reps attending other events, TUC events perhaps, but not training. Training actually comes under the paid time for representatives. But essentially, our human rights are that we are able to join trade unions to further our interests, and that's enshrined in United Nations charters and European legislation, European equality. Sorry, the Equality and Human Rights Commission in this country, and our own Human Rights Act. All of that is enshrined. So we have a right to be a trade unionist. And what it says, what this Trade Union and Labour Relations Act actually says, is that we have the rights under law to be able to perform our duties. And if we're not given that reasonable time to do that, then we have the right to go to tribunals. I don't know whether I've probably gone back on some of the same thing, really.
It's fine. Just while you were speaking there, quite a few people asked, can you clarify the distinction between duties and activities? And I'll throw in as well, like training. We obviously know what training is, but what's the main difference between duties and activities, and what can you have time for and not?
Okay. Under the ACAS Code of Practice, it's clearly laid out what it says, and in the Act, the 1992 Act as well. And it's the 1992 Act as amended. I always forget to say that, but that's an important thing, because it does change depending on the makeup of the government in power. But I think, first of all, duties are things that a rep has to do. So your pay and negotiations, your all of those lists that I mentioned before, and I'm just going to see if I've got them. So your terms and conditions of employment, any negotiations on that. So pay, hours of work, engagement, recruitment and selection policies, human resource planning, redundancy and dismissal arrangements, TUPE, allocations of work, job grading. So you have a right. Obviously, it's also it also depends on what your recognition agreement says, but usually the recognition agreement says it refers back to the examples in the Trade Union Labour Relations Consolidation Act, which means that you are able to do all of these. So disciplinary procedures, talking about them, changing them, trying to get a better thing that than you have, or a more consistent approach. Representational arrangements. You should also be getting accommodation, equipment, names of new workers to the union, to the workplace. So if somebody starts, and also for you to be able to take part in any inductions, to say what you want all of these are examples of duties, and it's quite clearly laid out. Now, for instance, I mentioned that in terms of activities, just let me make sure I give you the right information. I'm just picking up this the 170 section. Yeah, nearly there. Just one sec. I'll be there. Okay, I'm just going to. I can't find it the wording exactly as it says, but in terms of activities, it's everything else that you would do as a trade union rep. So, for instance, if you were attending a regional committee, that may have no bearing whatsoever on your employer. Therefore, it is not a duty; it's an activity. However, if it's a regional committee of part of the employer's business, and you are meeting reps from other of the same employer's different factories or sites, that is a duty, and that would be paid. If you wanted to go to the hazards conference, there are two things here. So if you're a health and safety rep, for instance, it's a big learning place. It's one of the things that your functions, as they are deemed under the SRSC regs for health and safety, is they have functions rather than duties. Same thing really, but they have a function to keep themselves abreast of the latest developments in health and safety law. So going to that conference may well attract a duty or a function which is paid, but part of it, the making having a good time there and meeting other people, may be deemed by the employer as not a duty, as an activity. They'll give you the time off to go, but they won't pay you for that part of it. And there has been case law where they've divvied that up. So, for instance, if there were sessions on the latest law, the latest thing, that would be training, and that could, under certain circumstances, be paid. The rest of the time, the fraternizing and getting to know people, making contacts, would not be a duty or a function. That would be that wouldn't be paid. So you'd have a differential in terms of your time off, some paid, not some not. But you would be given the time off totally. And there are other examples. For instance, if you are a rep and you've been discussing pay negotiations with your employer, you need to report that back to your members. You may do that these days via social media. You also may have meetings in the workplace. And if you do, that's one of your duties to report back. So you would be paid. Essentially, all of the members who attend, that would be an activity, and that would not be paid necessarily. But ACAS, both in the ACAS code and in the guidance, says it would be good practice for an employer to pay everybody. And this is an important point about all of this. The law is the minimum. You can negotiate better than the minimum, which is what we do all of the time. We negotiate hopefully better than national minimum wage, better than national minimum holidays, etc., etc. So never think that the law is the law. The law is the backstop. It's the floor of rights that we build upon with better negotiations.
I mean, you've hit the nail on the head there, John, that as we say with all aspects of being a trade union rep, the law is the minimum and we try to go above that. Just before I look to the questions that we have had submitted, several people have asked about conferences, and you've just explained where that you have to look at the content of the conferences to decide whether it can be paid time off or not. Hopefully, everyone, you have got the information you need. I think it's a bit of a case by case basis, but hopefully you've got enough information there to be able to apply it to your situations. Okay, John, a few questions we've had submitted before we sort of look to conclude, because we've already filled 45 minutes. Right, what if the employer doesn't recognise the union perhaps locally? What if there's a national agreement and then there's no recognition locally? What's the deal then with time off?
It would be, first of all of the rights under the Act comes from being a recognised trade union. However, there are particular rights under TUPE and under redundancy consultations, which attract the right whether you are recognised or not. So that's subsumed. We often just put all together because we're talking about recognised trade unions in the main. But in the times when there isn't one, those rights in terms of consultations over redundancies, TUPE transfers, they have, and also there's the ICE regulations as well. The information and consultation regulations provide the certain rights to employees of non-recognized trade unions to be consulted. And obviously what we would hope is that we would be having a fledgling, if you like, trade union branch in the sort of the early stages of one in those organizations. Um, and at the moment, don't forget, we also have, if you've got 50% plus one currently, we have, you have the right to apply for trade union recognition under the CAC um, um, organization. And once that is done, if you can't come to a voluntary arrangement, they will give a statutory recognition agreement. So we have that. That is always the way. So um, yeah, Anna, have I answered that question? Do you want more detail in that?
I think that's good. That's good for now because like we've had a lot of questions and I don't want to stay on one for too long. We've had someone ask what you'd advise if an employer drags their heels and makes you wait if you've requested time off for union duties. What would be an acceptable amount of time that they should get back to you, and what can you do if that is the case to make them hurry up?
Well, I think first of all, you would go through the internal procedures. You would, if necessary, raise a grievance, but you would try and resolve the issue before that. And I think sometimes it's a case of getting a full-time official involved, getting someone else involved, like HR, as well as the person that is being belligerent and preventing the time off. Um, it's usually advised that you don't take the law into your own hands and then take the time off anyway, because although the employment tribunal uh, wouldn't take that into account, it's actually you would potentially in breach of contract because you haven't got the agreement of your employer. So it's always best to have the yes, you can have this, and that's why those policies on agreements and time off are important in many cases because it just avoids all of this potential angst later on.
Thanks, John. Um, if an employer asks for details of what the rep is doing with their time off, how much, uh, how deep do they have to go into those that information? So, for example, if a rep says, I'm meeting with a member," is that enough? What if the employer asks more? Do they have to kind of explain themselves,
I don't
basically?
think so. No, I mean, I think you obviously what you've got to be is you've got to be reasonable in all the circumstances. So if they ask you a reasonable question, you should answer it. What you shouldn't do is sort of put up a barrier because essentially what you're trying to do at some point you may have to represent this person in a grievance or a disciplinary procedure or whatever it is, and you don't really want to start making enemies, if you like, right away. But um, there isn't there isn't in terms of what you should say. There has been cases and case law where employers have said, no, we're not going to allow you to do that training course because we think it is not relevant. And there's two ways of looking at it. One of them is that employment tribunals have said it's not what is relevant, it is what is reasonable in all the circumstances. But there have been other cases, and that the employer then has lost. There's been other cases where they said, well, it's not necessary for them to know all of this fine detail because we don't actually use it. And they've shown and they've got from somewhere the syllabus of the training. And the employer, again, the employment tribunal has often said, well, it's not what is necessary, it's what's reasonable in all the circumstances. So it's all about what's reasonable. Is it reasonable for you to go on a training course like this? And one of the requirements is that the training course should be provided by the TUC or your own union. And if that's the case, then there isn't much to argue about in a tribunal, really. But they can, there's all sorts of cases, and every case depends on the particular circumstances. So it's very hard. And lawyers will always say this, and I'm not a lawyer, but will always say it depends. And that's as much as I can say as well, really. So
So much of the law depends, doesn't it? Because it's on the facts.
Minute differences
For
sometimes.
sure, for
Yeah.
sure. Um, so you actually covered another question there really well, but I'm just going to point out to someone. You said that training that is reasonable is has to be approved by your own union or by us at the TUC. And someone earlier asked about webinars. Much like this one now, we say you are entitled to time off because it is a TUC training event, this webinar. It is on, obviously it's online, we're all joining remotely, but you are entitled to time off for this as well. Remember, if you do have issues getting the time off to train, you can always contact your full-time officer who's responsible for your workplace. If you're not sure who that is, do contact your union nationally, and then they can they'll be able to put you in touch with that person who who can help you. Right. I'm just looking at what other questions we've had because we've had a lot. And even if we don't answer every single one, just to reassure everyone who's watching, we don't ignore them. We do use them to inform other advice that we put out to you. So please don't think we're just ignoring what you've posted. Um, Okay, we've had someone ask about so they are an assistant secretary in their branch, but it's a shared position. So they're saying that they're getting problems getting a share of the facility time. And I know we've talked a bit earlier about how you divvy up an allocation. Is there sort of a formula that we could maybe use for some of the roles within a branch, or would it be a case by case basis?
I think it's going to be a case by case basis, and quite often we're talking about not just what the law says or what the union says. We're talking about personalities and people with various egos and so on within a branch without uh, making too much of a point of it. But yeah, and that sometimes needs a little bit more sort of um, sort of persuasion that actually the time required that you might have on a job share on a, if you like, similar to a job share as a, that actually you need more time, and that you've got to have that, and you have to negotiate that as not just with your employer, because your employer is given an overview of the amount of time that might ordinarily be used. Um, but also then you have to negotiate it within your trade union, within your branch. And that's like with everything else, you get people on side, you do all of the things to make sure that your point of view is heard, and so on. And obviously you could go back if necessary to your full-time paid official to get the advice and guidance on that. But I think it does often crop up that people think that they don't get a fair share of it. But don't forget, the overall view is that it is what is reasonable. And the time required to do a particular duty is a reasonable time to do that duty, and that can vary.
Thanks, John. We've had a whole bunch of questions that I'm going to try and put into one, but they're all on a similar theme. If a rep has done trade union duties on their days off, perhaps if they are part-time, for example, can they claim that time back from their employer? And also, kind of connected to this, it's around payment. Can employers ever, yeah, or of course, or shift workers would also be covered under that if they've done something out of shift. Can an employer ever claim the money, the time from the union to pay that rep, or is that not something that happens?
I haven't heard of that happening, and I think
No,
that
me
would be
neither, but I thought I'd check.
it would be a bad precedent, I think,
Hmm.
if that was the case. Um, I think what often happens is that on certain big employers that they're a national, that they will have in particular areas full-time paid laid officials, paid lay officials, so that they are paid full-time to do a union role completely. Effectively, it's been paid by the employer. And that had fell into a lot of questions, but actually it was necessary, especially with very large companies and employers. But I think with the pay for shift work, it's quite easy to say that, look, I had to do some work, uh, and I need time off to do it. So I mentioned before, meeting someone on the day shift, if you are the only rep in that workplace and you just happen to work on a night shift, for example, then that would be easy to show that it would be a reasonable request to have the paid time off, with time off on in terms of your working days and working nights. Just, you can't go from one to the other. You have to have particular rest periods in between. All of that has been established in case law, and actually there isn't usually a problem with that. What tends to happen is when people take it into their own heads and say, okay, I will come and see you, and then go retrospectively to the employer and say, oh, by the way, I didn't turn up for that night shift, but I actually did this instead. Then that throws the planning, organization, everything else, and you can understand that there may be problems there. So it's best always to go through, make proper requests and get the answer. If you've done work as a rep outside of all of this, and you're then trying to claim it back because you've done things in your own time, usually that would be a hard ask because you've already done it. And there's no requirement under the Act for an individual rep to be paid for time that they spend in their own time doing this. So it's all about making that request and then getting into the response, what the response back is. And
That's
then make a reasonable request and don't get it, then you can take it through from the tribunals, etc.
sure. Thanks, John. And I think I've saved maybe the best question till last because we were planning to speak about this last anyway. So we're going to tell you all about what hopefully is coming down the line in the new employment rights. Well, it's currently the Employment Rights Bill because it's not yet the law. So a viewer has asked about changes to facility time in this new piece of legislation. So to give you a bit of a positive note to end on, I'm going to let John explain what we hope will come soon.
Okay, thanks, Anna. That's great. Yeah. The first thing is that this is the bill, as Anna has said. It's hopefully the first thing it says is the government has said that they will repeal the vast majority of the Trade Union Act of 2016, and that will mean that. And I could see some of the questions coming through when I was reading it. The requirement for public sector employees to publish information on the amount of facility time taken by union officials will now be removed. The power to impose a cap on facility time in the public sector will also be removed. So quite often these were stumbling blocks that people were having, particularly in the public sector. It will strengthen the existing right to reasonable paid facility time to carry out your duties. And this is an important one, it will establish a presumption that the employee's view, the rep's view, on what is considered reasonable time off is reasonable in all the circumstances, and that the employer would have to show that it was not reasonable amount of time off. Okay, and it would require employers to provide union reps access to facilities as well. So at the moment it is guidance in terms of providing office space, etc., etc. This is going to be firmed up as well. So that is a sort of really important changes, which will really beef up our role within the workplace. Next slide. And there will also be a new statutory right for trade union equality reps to take time off. Now, we haven't had that in the past. Quite often, what we've done is we've hidden the equality reps role within the trade union reps collective bargaining role, if you like. This will be a new position, a bit like union learning reps. It will be equality reps, and they will have time off as is reasonable in all the circumstances, having regard to an ACAS code of practice for your working hours, for carrying out everything that you would do as an equality rep. ranging, learning and training on matters of equality, etc. So there's a whole new load of stuff that's coming down the road, which will beef up all of our rights and will amend the current Trade Union Labour Relations Consolidation Act with the outcomes of the bill.
Thanks, John. And we, of course, at the TUC will, as the law changes, and it probably won't be until later this year or even next year that these changes come into effect. We will, of course, bring you all the updates and the information that you need, either via webinars or by other training or our newsletter. Do sign up so that you can stay informed. Right, we have gone for over an hour, as I thought we would, on this subject. Thank you all so much for joining, and thank you, John. You've been absolutely brilliant. You've got so much good feedback already. Do join us again soon for another webinar about what is happening in the workplace, and we'll look forward to seeing you all again soon. Bye-bye for now.
Bye now.